When and why can there be a request to modify a final divorce decree? Attorney John Haughton explains, there are only certain parts of a divorce decree that you can modify. A decree becomes final after 30 days. You cannot modify a property division after the order has become final. However, matters primarily related to child custody and child support may be modified on proper motion to the court. Most commonly, modifications of Texas orders or decrees relate to the conservatorship, possession, and support of children. Regarding conservatorship or possession of the child, the court may modify an order that provides for the appointment of a conservator of a child, that provides the terms and conditions of conservatorship, or that provides for the possession of or access to a child if modification would be in the best interest of the child and the circumstances of the child or conservator or other party affected by the order have materially and substantially changed since the entry of the order the party is seeking to modify. The court may also modify orders related to the child if the child is at least 12 years of age and has expressed to the court in chambers the name of the person who is the child's preference to have the exclusive right to designate the primary residence of the child. Finally, the court may modify an order or decree related to the care and custody of a child if the conservator, who has the exclusive right to designate the primary residence of the child, voluntarily relinquished the primary care and possession of the child to another person for at least 6 months. This does not apply when the relinquishment is due to military deployment, military mobilization, or temporary military duty. The court may also modify an order or decree related to the care, custody, and support of a child within 1 year of the signing of that order or decree to modify the designation of the person having the right to determine the primary residence of the child if it can be shown that the child's present environment may endanger the child's physical health or significantly impair the child's emotional development. The person who has the exclusive right to designate the primary residence of the child is the person seeking or consenting to the modification, and the modification is in the best interest of the child. Or that the person who has the exclusive right to designate the primary residence of the child has voluntarily relinquished or given up the primary care and possession of the child for at least 6 months, and the modification is in the best interest of the child. Regarding modification of support orders for the child, the court may modify an order that provides for the support of a child, including an order for health care coverage or an order for dental care coverage, if the circumstances of the child or a person affected by the order have materially and substantially changed since the entry of the prior order, or it has been 3 years since the order was rendered or last modified, and the monthly amount of the child support award under the order differs by either 20% or $100 from the amount that would be awarded in accordance with the child support guidelines. If a party wishes to modify an order, and the order was agreed to, and the child support differs from the support which would have been ordered pursuant to the Texas guidelines, then the court may modify the order only if the circumstances of the child or a person affected by the order have materially and substantially changed since the order was entered. Some orders for child support issued by a Title 4D court can be modified at any time without a showing of material and substantial change in the circumstances to provide for medical support or dental support of the child if the order does not provide health care coverage as required by the Texas Family Code. At Haughton Law Group, PC, our decades of legal practice means that we can analyze your case quickly and accurately. We have acquired extensive knowledge in our chosen practice areas and also knowledge of the customs of the courts, judges, and attorneys throughout North Texas. We work hard to resolve cases fairly,